All right, going to the first of the court cases. This judge has ruled that AI training is fair use in the Anthropic case. In yet another courtroom loss for authors opposing the use of their works in AI training, a federal judge has ruled that training artificial intelligence models on copyrighted books now constitutes fair use. U.S. District Judge William Alsup in San Francisco ruled in favor of Anthropic, which is an AI company, in a lawsuit brought by authors Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson. The judge determined that using copyrighted books to train Anthropic's AI model Claude is fair use under U.S. copyright law because it is exceedingly transformative, which means it's taking the original material and it's turning it into something else. So, in the same way that you will read a book and be inspired by it, and you will then write your own derivative of that book, you also can't be dinged for copyright violation when you do that. And because of that, Claude cannot be dinged for doing the same thing.
Which means no original sin, right? So a lot of people who argue against AI use this phrase, the original sin of AI. I've never heard an actual Christian use that language because Christians actually have a rich theology around the concept of original sin and some debate. There's factions when it comes to our understanding of original sin. The Calvinists see it a little bit different than the Baptists do, potentially. We didn't even define who the they was. But a lot of anti-AI folks will talk about the original sin of AI and the fact that it was trained on copyrighted material.
Yeah.
And the judge, this was, I believe, a summary dismissal. So this didn't even go to trial. The judge looked at the kind of initial arguments of the case and just dismissed it. There's no case here to even have the trial because of how clear this is in terms of fair use. Because if you read The Lord of the Rings and then you write a story that has elves in it, inspired by reading The Lord of the Rings and it moved you, that is not a copyright violation. The fact that you read and were inspired by The Lord of the Rings. In fact, that is how art works. All art is inspired by all other art. That's how there's a zeitgeist. That's how there's a culture. You're making me very... You don't have to... let them play their own bingo, Jonathan.
I'm sorry. Am I throwing you?
So... yeah, this is I think a real nail in the coffin for this hope that the AI is going to, or that the courts are going to somehow stop AI or keep AI from training on copyrighted works. Now, there was a few things that should be brought up. The judge did suggest that there's a stronger case that could be made if authors demonstrated that AI training enables the creation of a potentially endless stream of competing works that could significantly harm the market for these books. He thought there might be a case there. There was also a ruling that you can't use pirated works. You do have to pay for copies of the books, which actually could be really good news for authors who haven't sold many copies.
Yeah.
But if you're selling one copy a month and there's a dozen different AI companies that
that's
all
12
buy a
sales,
copy
right?
of your book, you just boosted your sales by tenfold. So that's actually really good news potentially for authors.
Right. Now, this does contrast with an earlier case because people might start getting confused. They're seeing all these courts ruling on AI. They're not all the same kinds of AI. So the one in February 2025 where a Delaware court found that using copyrighted legal content to train an AI model was not fair use. The difference is that wasn't a generative AI. This thing was going to actually create stuff from this legal content that was going to actually compete directly with it because it was going to be more of the same. So that's not the same as generative AI, which is creating a new product out of an amalgamation of previous copyrighted products.
And the courts are dismissing these AI copyright cases so quickly. I'm of the opinion we shouldn't even cover them until they get dismissed. Like Jonathan wants to talk about every time Disney files suit against Midjourney, which is a lot of people are buzzing.
Well, this
about
is a
that.
major deal. We got Godzilla and King Kong teaming up against Midjourney now. That just came out yesterday, I think. They just filed against Midjourney for misuse of their IP images because people are generating images using Disney. And it's really easy. You just say, give me a picture of a yellow animated character and it gives you The Simpsons without being prompted further. And that's the whole core of their case here. So
And they're
that
using a
one's gonna be
totally
interesting to
different.
follow.
Yeah, they're also using an entirely different form of IP protection that's going to actually gives Disney a stronger case and makes this less applicable
Right.
for authors. And they're not claiming copyright infringement, which has fair use kind of attached to it, but instead they're claiming trademark violations. And trademark protections in the United States are very high. They don't expire the way copyrights expire, but most authors don't have trademarks for anything related to their books. They can't afford it because to just file for a trademark is like $10,000, $15,000, and that's if you do it like on the cheap. And then you have to defend it in court, which means $100,000 plus of court fees. So trademarks really are kind of the domain of the wealthy and really domain of corporations. And so these kinds of protections won't help you. And you wouldn't want to use Midjourney to put Bart Simpson on your book cover anyway.
Don't do that. Your book's
Because
gonna
even
go
if you
away.
won your court case, just going to court, you still lose your court
The
case.
mouse is going to rope out of the ceiling and you're going to go away.
Don't mess with Nintendo's lawyers. Don't mess with Disney's lawyers.
Exactly.
This is the
Exactly.
way.
These are the rules.